Welcome everyone to the latest Moorcrofts Employment Law Update webinar. We've got a packed session today. There we go, looking at the agenda. For those who don't know me, my name's Matt Jenkin. I head up the employment team at Moorcrofts. I'm also joined today by my co-presenter, Lindsay Abbott. Lindsay's also a member of the employment team. I'm really pleased to announce Lindsay's been promoted to associate in the employment team, which is real recognition of her valued contribution to the employment team at Moorcrofts. As we can see from the agenda, hopefully everyone can see the agenda. We've got a packed session. I'm going to be starting off by looking at the fallout from the PNL dismissals, which has really captured, I won't say the imagination of the public, but certainly has caught the attention of the public in a way that not many employment law news stories really do. Lindsay's then going to have a look at living with COVID as we come out of the pandemic. Obviously, there's some employment law implications there, as in the words of the government, we learn to live with COVID. We're then going to have a short break, hopefully give you the opportunity to recharge your caffeine levels, or in my case, to give the dog his mid-morning snack to avoid him making a guest appearance on the webinar at any stage. And when we come back from that, I'm going to be taking a look at the current state of employment law reform. And there's been a lot we've discussed over recent years in terms of the proposed changes, and I wanted to take a kind of look at where we are on that. And then Lindsay's going to finish off with an important case law update. Since we last spoke to you in November, there's been lots of interesting cases, and that's a session that's really well worth listening to, because there was some real learning points, I think, for employers from some of those cases. In terms of questions and answers as we go through, we've got the Q&A function, so please do use that if there's any particular questions and answers. We'll try and answer the questions as we go along, and if we've got time at the end, we'll try and have a catch up on that as well. And in terms of the conclusion of the webinar, you will all be sent a copy of the recording together with some of the source materials that we refer to. So that means if you're unable to stay on for the whole of the webinar, and we appreciate people have got busy mornings, then at least you'll get the opportunity to dip in at your leisure and see what sessions you missed, and you can catch up with them in that way. And if you've stayed right to the end, you've really enjoyed the session, then you can go back and revisit the session again at your leisure. So hopefully that's the kind of housekeeping out of the way, and probably leads me to start with my first session, which is PNL dismissals and the impact on employment law. And I think the PNL dismissals have probably been that kind of news story that really has captured the public's attention when it comes to employment law. And of course, we've seen headlines like these ones, where the decision of PNL very much caught certainly the press's attention, and I think the public's attention as a result. And I don't think you could describe any of those headlines as particularly favourable at all to P&O in terms of what they did. But just in terms of a recap, this is what happened. So on the 17th of March 2022, P&O Ferries dismissed 800 of its shipping staff who are based out of UK ports. Now, it's important, I think, as a starting point to say, although the ships were based out of UK ports, the ships themselves were actually registered in other countries, which will be important when we look at one particular aspect of the P&O dismissal. Now, what P&O did was that they terminated those employees with immediate effect due to redundancy, and they replaced those 800 employees with cheaper agency workers. And I'm sure we've all seen the stories in the press as to what they've been paying their agency workers, and particularly where those agency workers are based. Certainly it looks to be, certainly some of them are paid more than the national minimum wage would be if they were employed in the UK. Now, it's controversial, those dismissals, to say the very least, and not just replacing with cheaper agency workers, but also the method of dismissal. Certainly some of the employees, not all, some of them were notified of their dismissal in a 3-minute pre-recorded video call. Now, even taking the impact that the pandemic has had on communication with staff, notification of dismissal via a pre-recorded video is never going to sit well, and I certainly wouldn't encourage it as a method I could see an employment tribunal looking rather appallingly at any employer who decides that's the correct method of notifying employees of dismissals. There's also the use of security staff to escort crew off ships. We all heard the stories around balaclavaed security staff with handcuffs. And I think some of those stories may have been slightly exaggerated, but certainly it didn't help in terms of the optics of the dismissals, in terms of what P&O were looking to do. And of course, I think one of the biggest controversies was the lack of any process. And it certainly came as a surprise to the employees and the unions, and generally a surprise to the government, who I think had some notification the day before, but that doesn't appear to have been widespread or particularly detailed. And so what were the legal issues? Because immediately as an employment lawyer, I looked at that and started thinking, well, okay, P&O have made this decision. And I can't believe they took that decision without taking advice, but what are the potential claims that they're facing? Well, for those employees who had 2 years or more service, they could bring unfair dismissal claims against P&O, arguing that those dismissals were unfair. And that could be around whether or not those dismissals are genuinely redundant, satisfy the definition of redundancy. If you're replacing someone with cheaper agency workers, does that mean your role is redundant? And also looking at the process that was followed, that could lead to an unfair dismissal. Then there's a failure to inform and consult trade unions. Now, this is collective consultation, which some of those attending the webinar may have come across before. So this is the obligation on employers. If you're looking at making 20 or more employees redundant within a period of 90 days or less, there's a collective information and consultation process that you have to go through, which involves informing and consulting with appropriate representatives. The appropriate representatives in this case would have been the trade unions. And also, another legal issue is a failure to notify the Secretary of State in advance of the proposed redundancies. And this is the one that I think perhaps there will be difficulties over in the government being able to substantiate, and we'll look at that in a bit more detail. But really, where there's an obligation triggered for collective redundancy consultation on the part of an employer and with the appropriate representatives, there's also a similar obligation that's triggered at the same time, that they need to notify the Secretary of State in advance of the proposed redundancies. And it doesn't appear that that actually took place. Now, that's not something that the employees can action, but it's a criminal offence not to notify the Secretary of State. I'm sure the directors at P&O were very careful to make sure that they weren't exposing themselves unnecessarily to any potential criminal prosecution. Now, in this case, I think P&O appear to accept, as we'll see, that dismissals are unfair. I don't think there's any argument that they're going to run that in some way that what they did would be a fair dismissal if it went before an employment tribunal. They also appear to accept that they failed to comply with collective redundancy obligations. And I'm putting aside here any jurisdictional arguments that P&O might run if the matter went before an employment tribunal, although I think an employment tribunal would fight very hard to make sure that it did have jurisdiction to deal with some of these claims. What P&O don't accept is that they fail to notify the Secretary of State in accordance with their legal obligations. They say their obligation was to inform the government in the country where the ships were registered. And that was due to a change in the regulations that happened a couple of years ago. And so they say on that basis, they satisfied that, they did inform the government in the country where the ships were registered, and they didn't have any legal obligation to inform the UK government. Now, that seemed to come as a little bit of a surprise to the UK government, who I don't think quite appreciated the small print of the legislation. And it'd be interesting to see whether or not the government do pursue criminal prosecutions against the directors for this failure to notify the government of the redundancies. And I think if they do, there might be some difficulties in a successful prosecution. Now, when we talk about fair dismissals and collective consultation, really, we're looking at a failure to consult on the part of P&O. And I always think a good starting point, and I often say this to clients when we're looking at redundancy exercises, is the basis of a fair process is to consult with employees whilst the proposals are at a formative stage. There's little point saying to employees, we're going to make you redundant, let's consult. Because at that stage, what is there to consult about? You've already made your mind up. And so this idea that consultation really is king and is a key component of any fair dismissal rings through, I think, most redundancy processes. Now, this is a statement that was made by the CEO of P&O when he was exchanging correspondence with the government back on the 22nd of March. And that's one of the good things about the current information age we live in. And you get to see all the correspondence really that's passed between the parties. Now, in this case, on the issue of consultation, the CEO said the option of following a formal consultation process to implement the necessary changes was considered, but rejected as we took the view, in good faith, that reaching an agreement on the way forward would be impossible. And against this background, the process itself would be highly disruptive, not just to the business, but also for UK trade and tourism. Now, when the CEO was questioned in the Select Committee in the House of Parliament, he was a little bit more upfront than that, although that statement itself is fairly upfront. And he said words to the effect that they didn't consult with the trade unions because no trade union in their right mind would have agreed to the proposals that they were considering implementing. Now, I suppose you can give them credit for their candour in terms of why they didn't consult, but that's not an excuse for not consulting. Consultation is with a view to reaching an agreement, and for P&O to kind of second guess what the outcome of that consultation would be doesn't excuse them in terms of an unfair dismissal claim. It doesn't excuse them in terms of a failure to inform and consult appropriate representatives. Some of you, again, may be aware that in terms of collective consultation, there is a special circumstance of defence which employers can run to say, well, we didn't collectively consult, but there were special circumstances which meant we couldn't. Now, that special circumstances threshold is a very significant threshold for employers to overcome. And I don't think P&O would meet the special circumstances test by any means. And so they're going to be exposed to these claims. And so I think P&O recognise the prospect of claims from dismissed employees, because what they've done, and you may have read about this in the press, is they've offered settlement agreements to employees. And of course, in those settlement agreements, they're offering payments to the employees in return for waiving claims. And as I understand it, those payments that are being offered are pitched at the maximum levels that the employees could get if they pursued claims before an employment tribunal. So, for example, they include an element of a protective award up to 90 days pay that an employee could get for failure to collectively inform and consult. Now, given that they're pitched at that level, there has been, unsurprisingly, a high take-up rate amongst the employees. I'm only aware of one employee who hasn't signed a settlement agreement out of that 800 who were dismissed. There, of course, could be more in the background. And that one employee, I think, is claiming exemplary damages of up to 72 million against P&O, which, I can understand the sentiment behind it, but I would question whether or not ultimately they would be successful. As a result, I think that employment tribunal scrutiny may well be avoided, because those employees will settle the claims and never appear before a tribunal. The government investigations continue, and the government is, say, desperate, but is very keen to launch criminal prosecutions against P&O for failure to notify the Secretary of State. As I said, I think they'll have difficulties in successfully prosecuting P&O because of the change in the legislation. P&O didn't need to notify the UK Secretary of State. But of course, what has also happened is the government doesn't like P&O effectively thumbing their nose at employment law legislation, and we'll see loss of contracts and continued inspections of P&O vessels to make it awkward for the current management team at the very least. And so I think we'll continue to see that, even if we don't see any employment law claims going through the employment tribunal. The other fallout from the P&O dismissals is the impact that it's had on fire and rehire. And I've talked at previous sessions about fire and rehire. And before P&O, it was my intention to touch on it again because there had been an important case law development, but P&O has seen some further developments as well. And so just a refresher, what is fire and rehire? That's a method of amending contracts of employment. Essentially, there's three ways in which an employer can look to change the terms of an employment contract. First of all, you can just impose the change on your employees, a unilateral variation of the contract of employment. If you do that, it's a potential breach of contract and can lead to unlawful deduction of wages claims. It can also lead to unfair constructive dismissal claims. As you can imagine, unilateral variation of contracts of employment is not something that normally I would advise an employer to do as a method of achieving the change. The second option is to seek agreement with the employees to change their terms. And of course, employers reach agreement with employees all the time on changes to terms of employment, sometimes buying them out of the particular term that they want to change, but not also. That's not always the case. So what we'll see is employees agreeing to the change and then perhaps a variation letter being produced. But then what happens if you seek to negotiate with the employees or their representatives and you can't reach an agreement? You probably don't want to just impose the change on them because of the difficulties that could bring. So that brings us to the third method, fire and rehire, probably a slightly less emotive term, termination on notice with an offer of re-engagement on new terms at the end of the notice period. Now, this is an effective way of securing a change to the terms of employment. So what you would do is you would say to the employees, well, we want to introduce this change, you don't agree to it, so we're giving you notice, but we'll give you an offer of re-engagement on the new terms. If the employee accepts the new terms, then their employment continues with continuity of employment preserved. If they don't accept it, then their employment terminates at the end of that notice period. It's viewed as a dismissal, so employees with 2 years or more service could bring an unfair dismissal claim. But my experience of those claims is as long as the employer has followed a fair process, which largely involves good consultation, and there's a good business reason for introducing the change, employment tribunals are loath to uphold unfair dismissal claims in those circumstances. So it is a tried and tested method of securing a change to terms of employment, but it's certainly controversial, particularly when it's used in large-scale change exercises. We saw it with British Gas recently, where they used fire and rehire to change the terms of a significant number of their gas engineers. And because of that controversy, fire and rehire has come under scrutiny, certainly in the last 18 months, 12 months. But despite pressure, there's no plans by the government to block or limit its use. Indeed, the government decided to block a private member's bill last year that would have imposed some restrictions on the use of fire and rehire. What the government did do, though, was to update or ask ACAS to update their guidance on changing terms of employment. Now, ACAS did that. It's a really useful guide, actually, and if you're contemplating changing terms of employment, it's a good starting point. It's quite an accessible document in terms of the principles that it sets out. But it made clear that whilst fire and rehire was an extreme step and perhaps one of last resort, it could still be used. And that ACAS guidance didn't have any statutory import in any event, and the employment tribunals didn't need to take that guidance into account. But we also had this Usdaw case, which is a fascinating case because it involved a claim by Usdaw, the shop workers union, against Tesco stores. Now, in this case, the High Court issued an injunction on the basis of a claim by Usdaw. And this was to prevent Tesco from withdrawing a contractual benefit fire and rehire. A very short potted history is that this involved employees in the warehouse and distribution centres. When Tesco's changed the location of those centres, they gave their current staff something called retained pay, which was to encourage those people to move to the new locations. And that retained pay element of their remuneration was expressly stated as a permanent benefit. And lots of the communication from Tesco's was saying to these employees, this is a permanent benefit, we won't remove it. And a slight hostage to fortune, I think, for Tesco's, as we'll see, because Tesco's after a number of years saw the retention element of that retained pay as being less and less important. They wanted to remove it. And so they entered into consultation with the unions, which wasn't successful. Unsurprisingly, the unions didn't want to agree to removal of what was always described as a permanent benefit. So Tesco's wanted to go down the fire and rehire route. But before they could do that, Usdaw successfully applied for an injunction at the High Court and to prevent Tesco's from using fire and rehire to achieve the change. What the High Court said is there is an implied term in the contract which prevented termination on notice for the purpose of removing or diminishing that benefit. Now, that's very similar to the sort of cases you often get with permanent health insurance, is that there's an implied term in contracts of employment that you won't terminate an employee's employment if the impact of that would be to remove their permanent health insurance eligibility. Now, on the one hand, the case is very narrow in terms of its facts, is that not many benefits that I see are described as permanent in the way that Tesco's did. So I don't think it's going to lead to wholesale changes to the use of fire and rehire, but certainly on large scale exercises, I can see unions looking at the Usdaw case and looking to see if they can extend some of those principles out. And that was probably the most interesting development for the P&O case, because what we've seen is the government now deciding to step in and introduce some changes to deal with the use of fire and rehire. So at the end of March 2022, the government announced that it was going to issue a statutory code of practice on fire and rehire. And that statutory code of practice would involve a requirement to hold fair, transparent and meaningful consultations on the proposed changes. Now, because this is going to be a statutory code of practice, the tribunal is going to be required to take that code of practice into account. What does that mean? Well, that means that if an employer has failed to follow the statutory code, so they haven't held the consultations in a fair, transparent and meaningful way, that you could have an uplift of up to 25% where an employer unreasonably fails to follow the code. Now, I think that's an important message to send to employers, but actually, would it prevent, in this case, P&O making the decision? Well, first of all, it's slightly ironic because P&O isn't a fire and rehire case, in my view. P&O is a case of firing the current employees and hiring other employees to do their work at a cheaper rate. Nonetheless, P&O took a fairly upfront decision that they would, accept the risks that went with not following due process and effectively pay the price for doing so. And would another employer be prepared to pay a similar price, but just to uplift what they're prepared to pay by a further 25% to take into account any breaches that they may incur in not following the statutory code? So one to wait and see. Also, I think what's going to be really interesting is the details of the code. They're awaited. The government, as I understand it, has said that they will introduce the new arrangements once parliamentary time allows. And when you see my session on reform of employment law, you'll see that phrase used a lot. And I'm not sure where the particular bandwidth is in Parliament to force through this change, particularly if they've got to write the statutory code of practice first. But I'll be interested to see things like, is it going to apply to all employers who are going through a change exercise? So, or is it going to be limited to large-scale change exercises? So a little bit like the collective consultation. So if you're proposing to change 20 or more employees' terms and conditions, or would it apply if you were just looking to change terms and conditions of one employee? So there's lots of details to be considered. But what it does show that the government has now recognised, I think, that there needs to be some statutory rules around the use of fire and rehire to prevent some of its more significant excesses. So, as I say, while I don't think P&O is a classic fire and rehire case by any means, it's nonetheless going to result in some changes to the statutory to change in the use of fire and rehire that the government's been resisting up until now. Hopefully that was a useful overview of the P&O situation. I know lots of my clients were asking me about it. Lots of people, lots of friends of mine, when we were meeting up, were asking me about it, wanting to know how P&O got away with what they did. And I think it's a phrase sometimes that people use with employment law, is that employers often can do what they want as long as they're prepared to write a big enough check. In P&O's case, they were prepared to write a big enough check. If that's going to change, then you would need to fundamentally change employment law so that decisions and dismissals couldn't be implemented unless a fair process had been carried out. But in the UK, it's about the compensation that employees are entitled to for not following that process, that the approach that's taken. Hopefully you found that overview useful. I'm going to now hand over to Lindsay, who's going to have a look at our next session, which is going to be around the fallout from the latest on COVID changes. So Lindsay, over to you.
Good morning, everyone. And thank you for your comments in the chat. Right, hopefully I can share my screen and everybody can see that. I'm going to be talking about living with COVID this morning. So living with COVID, it's no longer a pandemic. This is something that we're living with now. So it's endemic, and we're all having to come to terms with that. So the government has announced its living with COVID strategy, removing the remaining restrictions that we were all subject to, whilst also attempting to protect the most vulnerable and maintain resilience against this disease. So what have we seen so far? From the end of February, we've seen the removal of the legal requirement to self-isolate if you've had a positive test. So we're now on guidance to stay at home. The free COVID testing ended on the 1st of April this year. Contact tracing has also ended, and self-isolation support payments for those on low incomes has also ended. So what is this going to mean for employers? Well, probably not that much in the short term. Most employers still recognise that employees who test positive should stay away from work, and employers still have health and safety duties to staff and customers and visitors and so on. But now employers have more responsibilities to manage COVID themselves, because obviously these restrictions have been removed now, and rather than this being something that the government is dictating to them, employers need to balance the risks of this disease, especially for more vulnerable staff. So we've got the end of also of mandatory risk assessment. So the employer doesn't have to specifically consider COVID now when doing risk assessments. They still have to consider, or they should impose their own, or can impose their own requirements within reason to manage risk, and obviously to consider the needs of perhaps more vulnerable employees and potentially clients and customers as well. Employers should speak to staff if the staff have any concerns, or if they have any concerns or any needs, for example, any reasonable adjustments for certain staff. Employees are unlikely to want to test regularly if they have to pay for that themselves, which is something else worth bearing in mind. If the employer is going to require the employee to test before they come into the office or the workplace, then that is something that the employer should probably be paying for. Okay, so vaccinations in the workplace. We've seen the end of mandatory vaccinations in the health and social care sector. That is something that was coming into force, but that has been scrapped now. So implementing any mandatory vaccinations elsewhere in another setting could be quite difficult, depending on the sector it is. So I wanted to talk about a case, a relatively recent case of Alette and Scarsdale Grange nursing home. So this was something, this case happened before the government announced that they were going to do mandatory vaccinations in the health and social care sector. And it happened around December 2020, which was just, you may remember, the vaccination rollout started happening. We started to see all the vulnerable and the older members going for vaccinations, but also more importantly, nursing homes and care homes were made a priority at this time. So this was obviously something to combat the particular vulnerability of that sector. As we all know, social care homes were hit very badly with COVID. Now, Scarsdale Grange had made arrangements for their staff to have vaccinations at the end of December. Now, unfortunately, that care home was hit by COVID quite badly, as many others were. Several members of staff contracted COVID, included the claimant, and many residents also. There were many deaths amongst the residents as well. So the claimant contracted COVID-19 and she had to self-isolate. She'd been employed for since about December 2007, so she did have quite long service with the care home as well. Now, Scarsdale Grange rescheduled the vaccination for her because she missed it because she'd had COVID. As I said, mandatory vaccinations in care homes hadn't been legislated yet. But the day before she was due to go for the rescheduled vaccination, she'd realised it was mandatory and she had to go, otherwise she was going to lose her job. Now, before that, she'd just understood that the vaccination was encouraged and advised, but not that she would be dismissed if she didn't have it. So she then had a very long telephone call with one of the directors of Scarsdale Grange, and she said that she didn't want to go for the vaccine. She wasn't going to have it because she felt that it had been rushed through without proper testing. She didn't trust it, and she thought that there was also a government conspiracy relating to the vaccine. The employer, Scarsdale Grange, held a disciplinary hearing with the claimant for the failure to follow a reasonable management instruction. At that disciplinary hearing, she said that the reason that she was refusing was because of her religion, and her religious belief was Rastafarianism. Now, the care home said to her that their insurers wouldn't provide public liability insurance if unvaccinated staff were found to have passed COVID on to residents or a visitor. And they also had similar issues with their employer's liability insurance. And they said, we can't make an exception for you. We're going to dismiss you for gross misconduct for the failure to follow a reasonable management instruction. So she brought claims of unfair and wrongful dismissal, and the tribunal rejected those claims. The dismissing officer did have a genuine belief in her dishonesty. So he didn't believe that she really was genuinely not going for the vaccine because of her religious belief. He felt that the real reason was the reasons that she'd given in the first place, was that she didn't trust it and she thought there was a conspiracy. One of the issues that the tribunal were considering was whether or not the employer had breached Miss Allet's right to respect for her private life under Article 8 of the Human Rights Convention. And the tribunal found that the employer had a legitimate aim for the management instruction to comply, to get vaccinated. And her dismissal was for unreasonably refusing to comply with that instruction. And it wasn't disputed that the key legitimate aim in this case was to protect the health and safety of staff, residents, and visitors. So at the same time, the tribunal did believe she was genuine about her fear and her skepticism, but that needed to be balanced against the fact that the nursing home was a small business who had a legal and moral obligation to its staff, its visitors, its residents, and that any interference with that private life of hers was proportionate. And so therefore, this was within the range of reasonable responses open to a reasonable employer. So we all know the issue of vaccination in workplaces is not straightforward. There are also a lot of wider issues, which I think I spoke about in the last webinar, everything from unfair dismissal, health and safety, to discrimination. Now, this is only a case that happened in a tribunal, so it's not legally binding on other courts, but I think it's a very useful indication, particularly to those in the care sector, that it is important to know that, yes, each case would be decided on its own facts, but dismissing an employee for failing to get vaccinated is risky. It's still very risky, and you do have to justify it and show that it is a proportionate means of achieving that legitimate aim. And obviously, you've always got to follow your own procedures and keep a paper trail as well. Okay, so now I'm going to be talking about sick pay. What's happening with sick pay now? So sick pay for those who test positive for COVID. Now, if an employee has tested positive for COVID, but they're still well enough to work and they can work from home, then they can be paid as normal. So we don't have to worry about them. The government has now closed the SSP rebate scheme, so we're going back to the previous SSP rules. Previously, statutory sick pay was being paid from day one for employees who tested positive for COVID but couldn't work from home. But that's gone now. So we've reverted back to paying SSP from the 4th qualifying day if the employee is off sick, regardless of the reason. If the employee is too sick to work, whether that's for COVID or for anything else, they would still need to follow the absence reporting procedures that the employer has in place, and they would be entitled to sick pay in the normal way. As I said, fourth day of the period of incapacity, unless you've got company or contractual sick pay, in which case you follow your own policy on that. Now, what about employees with mild symptoms who feel perhaps not well enough for going in, but probably pre-pandemic they would have struggled in? We've all gone to work with coughs and colds, haven't we, before? And we've sat next to somebody who's coughing and spluttering and think, well, perhaps they should have stayed at home. Without taking a COVID test, these employees are not going to know whether they've just got a common cold or whether they've got COVID. And the government guidance doesn't really give us very much help on that. It's really down to the employer to come up with how they're going to deal with that. And whether or not they're going to advise employees to stay at home just as a precautionary measure if they've got symptoms of any kind, even if it could just be a cold, or whether the employers are going to carry on workplace testing. They might wish to continue with that. Some employers might want to screen for positive cases and require a negative test before the employee comes into the workplace. If employers want to continue to do that now that the free testing's ended, then they should be looking at paying for that. And if asymptomatic COVID positive employees can't work from home, then employers have got to pay them in the normal way, sick pay in the normal way if they've got to stay home. Obviously, this is going to be a matter for the particular workplace setting, the workforce, and whatever risk assessment you've done. So as an employer, you'd have to have a look at that and see. Obviously, we can see that the risk of coming into contact with COVID positive colleagues and clients is going to increase now that we're all back out there. So clinically vulnerable employees might be slightly worried about that. So employers will need to consider how to meet their duty of care to them. For example, putting them in different safer roles or something like that. Employers don't owe a duty of care to those who live with their employees. So if your employee lives with someone who's clinically vulnerable, they might be anxious about that too. So employers might need to extend mitigating measures to those employees. And you might need some input from your occupational health team on that. And you might get more flexible working requests because of that as well. So you might want to have a look at your sickness absence policies off the back of that, take some advice from us on how to deal with that and having to work from home, for example, if employees can and they've tested positive. But employers, moreover, should be still complying with all the necessary requirements for cleaning and ventilation and so on. So employers also have a duty to consult with employees and their reps on health and safety matters. And there's some good guidance on the Health and Safety Executive website if you require any further assistance on that. Okay, so now I'm going to be talking about home workers and hybrid workers and the right to disconnect. So as COVID restrictions end, we're looking to return to more normal life, but we have seen the growth of more home working and hybrid working over the last 2 years. With the government rollout of the Living with COVID strategy, we're starting to see some return to normal life, but obviously that's very different from what we were used to 2 years ago. Allowing staff to work from home opens up the working marketplace to employers because you're able to recruit staff from more widespread locations and cast your net a bit wider so you can draw from a bigger talent pool if you've got people working remotely. And employees are also expecting more from their work-life balance as a result of the pandemic, and more people are expecting to work from home as part of a normal working arrangement. So we're seeing more employers favouring this kind of hybrid combo of a bit at work and a bit from home, rather than fully remote, because employers obviously recognise the need for that sort of collaboration, and also perhaps for some more junior members of staff, you've got training needs and so on. But issues can arise about how home working arrangements operate. And obviously employees are used to the convenience of that, because they've been doing it largely without issues for the last 2 years. So there have been some discussions about this and about how the home life and the work life is becoming blurred. People are logging on and they're available 24/7. So how do we disconnect? Should we all have the right to disconnect? This is hidden over time, and the expectation that you should be answering emails outside of working time, working hours and at weekends and so on. Now, the Scottish Government have announced that they're going to be having some discussions on establishing a legal right to disconnect for employees. And they've said that this will offer a balance between the opportunities and flexibility offered by technology and our new ways of working to support the need for staff to feel able to switch off from work. So they're looking to introduce a right to allow workers to disconnect outside normal working hours and not be available 24/7. So what can be learnt from Europe? Well, this right has been available in France since 2017. So employees have a legal right not to answer email outside of working hours, outside of normal working hours. Portugal's also introduced a similar right this year, and this is also a right in Ireland. Now, a recent poll by the Prospect Union said that 2/3 of remote workers would welcome this right enshrined in law. Many employees have been working and burning candle at both ends during the pandemic, and those staff have no boundaries. So in that case, this is about employers recognising that, recognising staff well-being, basically, which is obviously being talked about a lot at the moment as well, and getting that balance between the work and the home life so that employees are not always switched on, but hopefully employers will then get more productive and satisfied staff. I think the sensible approach in this case for any employer is to be a compromise that meets the needs of the business and the needs of the employees as well. This is true particularly when employers want to retain talent and not lose staff to other places. But it is crucial for an employer to have clear policies around home and hybrid working. So have a look at those. You've got some policies on home and hybrid working. Make sure that they're all up to date, and that you're also meeting your employment law obligations in respect of health and safety and staff well-being. I was on a course recently, and the speaker came up with a really interesting analogy about home working and not having any sort of switch off time. And he likened that to a horse grazing in a field. And he said that if you don't put any boundaries or fences up for a horse, the horse will eat the grass in its field, and then it will just carry on going and keep eating the grass until it becomes ill. And that was his analogy. So fences and boundaries hopefully will lead to more productive and satisfied staff. And I think we're going to go to a break now, but I'm going to hand over to Matt.
Lindsay, we just had one question come through, which I just wanted to pick up with you whilst we can. When you were talking about COVID tests,
yeah,
someone's asked, is that a lateral flow test or a PCR test?
I understand it to be the lateral flow test.
Yeah, that was my understanding as well. But I thought we'd just pick that up because it's a specific question to your session. So yeah, that's what I understand it to be. So they were free, and now they're not. So if employers were going to require that testing, I mean, it would obviously ultimately be up to the employer and that particular workplace setting. But that's what was happening in a lot of workplaces, that the employer would require the employees to have a negative lateral flow before they came in. Start the next session, and I'm going to look at the current state of employment law reform. And really the thinking behind this was, I'm conscious that over the last few webinars I've talked a lot about proposed employment law reform, various consultations with the government that could lead to changes to employment law, but I'm just conscious that the government's not actually produced anything in particular in terms of a lot of the changes. So I thought now was a good opportunity to have an overview of some of the changes, look at when perhaps they may be introduced. So let's start now. What I put here is kind of a table up of what the changes are. I'm not going to go through every element of the forthcoming changes on here because of the time. And what I'll be doing is I'll share this document with you as part of our follow-up, so that you've got that to have a look through again. But I just wanted to touch on what I thought were the main areas of employment law that have been trailed as changing, but whether or not will actually change anytime soon, we'll have to wait and see. So we've got the employment bill, which is really a bit of a hodgepodge of employment legislation. There's no one common theme that runs through it. You'll see this idea of a single enforcement body for employment rights and tips to go to work as in full. There's also going to be a right to request a more predictable contract. That would be for 0 hours contractors who want to get a more stable working pattern. They could, the employment bill is introduced, request a more stable working pattern from their employer. So have set hours rather than this guaranteed hours that they currently work on. We're also going to see protection for or extended protection for maternity and pregnancy and maternity discrimination. And that's extending the redundancy protection. As I'm sure some of you will be aware, that if you make an employee redundant whilst they're on maternity leave, that employee has a priority right to be offered suitable alternative employment that's available before any other employee. Now, that's a right that only applies during maternity leave. And there is a view that that's been used quite cynically by some employers who are making employees redundant before they go on maternity leave or when they come back, when this priority right doesn't apply. The changes that they're talking about under the employment bill would extend that protection so it covers an employee as soon as they notify the employer that they're pregnant before they go on maternity leave, and also covering for a period of 6 months when they return from maternity leave. We're also looking at some increases to what kind of you would classify as family-friendly rights as well, leave and pay for neonatal care, and a week's unpaid leave for carers. Also, the employment bill was supposed to touch on and deal with flexible working. Now, the government's headline is making flexible working the default. I actually think that's a slightly misleading description of the proposed changes for flexible working. I think we touched on them in the last webinar. What we're talking about here is not making flexible working the absolute right of employees. And it would still be giving the employees a right to request flexible working. Now, that right to request would be a day one right under the proposed changes, rather than having to go through the current qualification period. And as well as making it a day one right, they would change some of the procedure elements of flexible working requests, hope to make it easier and cut out some of the red tape that's still involved in making a flexible working request, but ultimately it would still be a flexible working request process. Now, the employment bill was first trailed in the Queen's speech in December 2019. Now, in 23rd of March 2021, when the government was asked the question about when it would be introduced, it said when parliamentary time allows, which you'll see is a phrase that's being used a lot at the moment in terms of employment law reform. Now, in May 2021, there was no mention of the employment bill in the Queen's speech. Again, when the question was asked in January of this year about the introduction of the employment bill, we were told when parliamentary time allows. And I think that started the alarm bell ringing for lots of employment lawyers, because there seemed to be no particular urgency on the part of the government to introduce the employment bill. And what we've seen is actually reports in April 2022 that the employment bill will be excluded again from the Queen's speech. Some of the reports I've read suggest that officials were told to stop working on the bill in March or April this year. And if that's the case, it's unlikely that we're going to see that in the Queen's speech this year, which means it could be a further year before it's thought about being introduced. So something that was first trailed back in 2019, I suspect that we will be waiting a considerable period of time before any of those things that I've mentioned that the employment bill would cover would be introduced. The next one I wanted to touch on particularly was consultation on reform of post-termination non-compete clauses in contracts of employment. Now, these are clauses which prevent employees, from going to work for a competitor once they've left their employer or setting up in competition. The proposals the government first talked about in December 2020 weren't going to change the current approach with regard to non-solicitation or non-dealing clauses. We're just talking here about non-compete clauses. What the government was proposing was either prohibiting the use of non-compete clauses completely in contracts of employment, or restricting their use, or even adopting an approach that some European countries take, which is that if an employer wants to enforce a non-compete against a former employee, then the employer will have to pay that employee for the period of the non-compete restriction. Now, in terms of that consultation, it started in December 2020. Now, the consultation is now closed, and the government said it will publish its response in due course. Now, my initial thought when I saw this consultation was that I didn't think it had much legs. The government had actually consulted on reform of post-termination restrictions back in 2016. I actually sat on the Employment Lawyers Association committee that responded on behalf of the ELA to that consultation, and that response gave the proposals in the government pretty short shrift back in 2016. And I thought they'd go the same way in terms of the latest proposals, even though they were more narrow in their approach, because we're just talking about non-compete clauses here. My only slight view on that that's perhaps changing is that the government is sort of talking an awful lot about entrepreneurship at the moment and encouraging entrepreneurship as a way out of some of the current financial difficulties. Now, one of the reasons they want to introduce reform to non-compete clauses is they hold up Silicon Valley as an example of entrepreneurship. And California, of course, where Silicon Valley is based, prohibits the use of post-termination restrictions completely. And there's a thought that if we were to remove non-compete clauses, then we could reignite entrepreneurship in the UK on the back of that. So I think the more I hear the government talking about entrepreneurship and trying to promote that, the more I'm starting to think there may be a slight chance of actually some reform to non-competes coming through. But I don't think it's going to happen anytime soon. You know, the government's not even using the dreaded phrase when parliamentary time allows with regard to this. It's just they'll introduce it in due course. And I also, on this next slide, I wanted to touch on ethnicity pay gap reporting, because this is one that I actually thought would go through relatively quickly. Consultation ran from October 2018 to 11th of January 2019. Now, with ethnicity pay gap reporting, of course, we've got compulsory gender pay gap reporting, and ethnicity pay gap was seen as the next stage in this. The whole point of gender pay gap reporting and the proposals on ethnicity pay gap reporting was the starting point if you want to deal with the gap in gender or ethnicity pay, was to find out the extent of the problem. And in order to find out the extent of the problem, you had to get employers to report on the gaps in their organisation. And I can see some validity for that view. And I think by and large, gender pay gap for large organisation reporting has been successful. We certainly have more information. Whether or not employers are actually doing anything with that information, I think is the next step. But certainly in terms of an information gathering exercise, it's been helpful. And I think the natural extension of that was going to be ethnicity pay gap reporting. However, and that's not to say that ethnicity pay gap reporting didn't have its challenges, particularly in how you would get people to describe particular ethnic groups within the UK. There's some challenges around that, but nonetheless, I don't think it was insurmountable. And I thought this was one that was going to go through, frankly. And I was really surprised, therefore, when I saw on the 17th of March 2022 that the government announced that ethnicity pay gap reporting will not be made mandatory. What they're going to try and do is encourage voluntary ethnicity pay gap reporting. And for some employers, I think that will be something they'll embrace. Employers will see that perhaps as part of their retention and recruitment program, and trying to show that they're treating this issue seriously, candidates. And I think that's something that will happen for some, but not for all. And if we think about gender pay gap reporting, initially the government resisted introducing any compulsory gender pay gap reporting and tried to encourage voluntary reporting. That didn't work. The take-up rates were still really low. And I suspect we'll see the same with ethnicity pay gap reporting on a voluntary basis. I don't think it will lead to the level of information that's required. And I think this will very much now be on the back burner until perhaps a period of a year, 2 years, when we perhaps see that voluntary reporting doesn't work, and that you need to introduce an element of compulsory reporting to get that information. So again, I was quite surprised that didn't go through. I didn't think it was hugely controversial in terms of what they were suggesting. But certainly the current view is it's not going to be made mandatory. Sexual harassment, I wanted to just give an overview of what the changes were, because these have long been trailed back in December 2018 in terms of some of those consultations. First of all, they were looking at dealing with the misuse of confidentiality clauses and non-disclosure agreements and settlement agreements. This was very much on the back of the Me Too campaign, and the thought that some employers were really gagging employees from talking about the way that they've been treated, to an extent that really the employer wasn't then having to address those issues. And so what they're looking at is restricting the use of confidentiality clauses, non-disclosure clauses in settlement agreements. Now, although there's no current timescale on implementation of this, it's still something that I don't think employers can completely ignore. The Solicitors Regulatory Authority, who are my regulatory authority, introduced guidance and requirements for solicitors when drafting settlement agreements on the use of confidentiality clauses, which really led to a sea change in the drafting of those clauses. I'm still seeing some settlement agreements that have historic wording in that wouldn't meet the new SRA requirements. And what I'd suggest for those who are listening, if you are using template settlement agreements, you just go back and revisit the wording of those to make sure that they're in line with the SRA obligations, irrespective of any consultation, implementation by the government. The government was also looking at the introduction of mandatory duty to prevent harassment in the workplace, backed up by a statutory code of practice. Also introducing, or perhaps reintroducing, protection against third-party harassment. For example, if an employer runs a call centre and one of its employees is harassed by one of the customers ringing into that call centre, then the employer could, subject to a reasonable steps defence, be held liable for that third-party harassment. And I know lots of my clients were looking at the measures that they've needed to put in place for third-party harassment. I still think it's one that you should do, irrespective of whether or not consultation is implemented, but certainly there's no legal obligations in terms of protection against third-party harassment at the moment in terms of employment tribunal claims. And they're also looking at extending the 3-month time limit for bringing all workplace and harassment claims, discrimination and harassment claims, from 3 to 6 months. Now, again, this was a relatively uncontroversial change and could have been done quite easily in terms of changing time limits when people need to lodge claims before an employment tribunal. But as we'll see from its current status, all this consultation on the changes to sexual harassment protection for employees in the UK, all that consultation is closed, and we simply do not know the implementation dates at the moment. And I think if you're looking at the various priorities that they have, if the employment bill isn't going to be introduced yet, and I'm struggling to see when the government's going to find time to introduce some of these important changes, increasing protection against sexual harassment in the workplace. And also worth mentioning is employment status and the Taylor review. I was looking back at my notes as when I've been doing these sort of webinars and seminars. And Taylor review was actually published back in July 2017. And I remember it well because I was actually doing a seminar on the day it came out. I think it was at the Magic Circle in London, of all places. But it did involve a fairly rapid change to my slides on that date. The Taylor review was largely designed to look at the change in the modern way of working, particularly the gig economy. And what it talked about in that review was the fact that our current thinking around definitions of self-employed, employed and worker were rather outdated and needed to be reviewed. The government's been through a whole series of consultations on employment status. And they've said that they intend to legislate to improve the clarity of the employment status test, which I think all employers would welcome, because that isn't clear at the moment. But as we can see, the government's response to this employment status consultation is awaited, and that's been awaited for a long period of time. And I just can't see that there's particularly any urgency on the part of the government to introduce that. What does that mean for employers? It means that in the absence of any clarity in terms of legislation on employment status, the running is now going to continue to be made before the Employment Tribunal, the Employment Appeal Tribunal, the Court of Appeal and the Supreme Court. And we'll continue to see all those cases that we've seen along the lines of the Uber status case, the Deliveroo status cases, the Pimlico plumber status cases. And Lindsay, I know, is going to touch on a couple of status issues in case law updates as we go along. So I think I'm pretty disappointed in it, simply because it was triumphed the Taylor Review as a real kind of a sea change in the way in which we approached the idea of employment status, which I think was long overdue in the world of the gig economy. We're just not seeing any movement on that at the moment. The last one that I wanted to mention was just the reform of statutory sick pay. And this was a really interesting one. It came out of the consultation that Health is Everyone's Business, proposals for reducing ill health related job loss, a recognition that actually the way in which we deal with sickness absence in the UK needed to be improved upon. And certainly the statistics show, don't they, that the longer that someone is out of work due to ill health, the less likely they are to return to that particular job and also perhaps to full-time employment. And there was a recognition that as part of that, perhaps statutory sick pay needed to change, and they were looking at changing some of the rules, including enabling statutory sick pay to be paid during phased return to work following sickness absence. So rather than this very black and white approach of you're either sick and you get SSP, or you're able to do some work and you don't, have a halfway house where people will get compensation to encourage them back to work on a phased basis. I thought the response on this was quite curious from the government, because they seemed to acknowledge that reform was overdue. But they said that now was not the right time to introduce such changes. At the time, in July 2021, of course, we were just coming out of the pandemic, so you can sort of understand the thinking behind that. But as we move away from the initial aftermath of the pandemic, I think there'll be more pressure on dealing with health and absence in the workforce. And certainly I'm working with a lot of clients at the moment when it comes to issues of ill health and how they deal with absence management. And I know lots of employers are doing good work through particularly employee benefits providers to try and deal with that as they go along. So I think disappointing, because as you can see, we've got a whole raft of legislation which is just on the cusp of being introduced, but actually we've seen nothing to suggest that it is going to be introduced. I've had a really interesting email come in just before I hand over to Lindsay, or a question come in just before I hand over to Lindsay to deal with their case law update. And that's someone's asked, has there been, or do I foresee any particular employment changes now the UK is no longer a member of the EU? If you've asked me that immediately after Brexit, I'd have said no. The government said they were going to increase worker rights, and indeed the employment bill was introduced to try and reassure employees and trade unions that the government took worker right protection seriously. And of course, EU derived employment law is enshrined in UK employment law at the moment. So it would take a conscious decision from an employer, from the government, to change EU derived employment law, which they can do. They'd have to do that via legislation. Now, I think the government will be under pressure for talking about this kind of bonfire of EU red tape, and whether we'll see some employment law legislation changing on the back of that. An obvious candidate perhaps would be to change the rules on working time regulations, because they're derived from the Working Time Directive. They could, for example, simplify the calculation of holiday pay, which I think for lots of employers would be welcome, but not perhaps so welcome by employees. So I think my view on this has changed in terms of, do I foresee particular employment law changes? I think we will see some changes, because I think the government is now looking actively at demonstrating that Brexit had an impact and that they could change some EU-derived legislation, and employment law is going to be in the firing line for that, I'm sure. Hope that answers the question on that. I'm going to hand over now to Lindsay, who's going to finish off our webinar with an interesting look at some employment law cases. And it always fascinates me as we look back over the last 6-8 months since our last webinar as to the sort of changes that have come through. And I know Lindsay has got some real interesting cases to go through. So Lindsay, over to you.
Thanks, Matt. Right, can everybody see that? There we go. Oh, I need to click through. Okay, there we go. So we've had some really interesting cases recently, as Matt was saying, and we're going to kick off with the first one, which is a case about vexatious grievances and dismissals. This is a case called Hope and British Medical Association. Mr. Hope was a senior policy advisor who was dismissed for gross misconduct. And what he'd done is he'd brought several grievances against senior managers. And he'd started off by having an informal discussion with his line manager about these grievances. But his line manager didn't have any authority to resolve these grievances in any way. So he was told to make it formal and invited to attend a grievance hearing. The hearing was arranged, but Mr. Hope refused to attend. He was informed that his attendance at the grievance hearing was a reasonable management instruction. So he wasn't there. The hearing proceeded without him, and his grievances were not upheld. The BMA said that the bringing of numerous vexatious grievances and his refusal to comply with the management instruction to attend a grievance hearing amounted to gross misconduct, and he was dismissed for that. Also important in this case is not only did he refuse to attend the hearing, he also refused to withdraw the grievances. So the employer found themselves a little bit in no man's land as far as that was concerned. So he brought claims in the Employment Tribunal and eventually appealed to the Employment Appeal Tribunal, who both agreed that the dismissal was fair. It was reasonable for the employer to conclude that Mr. Hope's behaviour had been unreasonable. He argued that the tribunal had failed to consider whether his conduct was capable of amounting to gross misconduct in the contractual sense. And it was held that it wasn't necessary for the employer to show that he had willfully committed a breach of contract or that he committed gross negligence in order to find out that he had committed an act of gross misconduct. I think this is a cautionary tale for employees who are sometimes messing about a bit or bringing vexatious grievances, which does happen sometimes. And it shows employers that you don't have to be backed into a corner if you have got an employee who's bringing repeated and vexatious grievances. However, what I would say in relation to that is, if you're faced with an employee raising vexatious grievances, you may think they're vexatious. The employee might be the most difficult employee that you've ever dealt with, but please be careful how you deal with it, because you can't just dismiss someone if you feel their grievance is vexatious for gross misconduct. Any action that you take really must be fair and proportionate in all the circumstances. So that's something to bear in mind. Okay, we're now going to talk about the case of Smith and Pimlico Plumbers, and I think I spoke about this in the last webinar, and I think I spoke about it in the webinar before that as well. This is a long-running, high-profile case, and this is a Court of Appeal decision. So you might remember Mr. Smith worked for Pimlico Plumbers with a contract that was originally described as an independent contractor of a company in business on his own account. Now, he successfully argued that he was a worker in the Employment Tribunal, and that went all the way up to the Supreme Court. Now, he also wanted repayment of holiday pay. He had been taking his holiday, but his holiday hadn't been paid because, to all intents and purposes, and according to Pimlico Plumbers, he was self-employed. Now, workers in the UK and employees are entitled to 5.6 weeks paid holiday. Now, 4 weeks of that comes from European law under the Working Time Directive. The remaining 1.6 weeks is domestic law. Those are our 8 bank holidays. So you can bring a claim for holiday pay as an unlawful deduction from wages claim under the Employment Rights Act, or as unpaid holiday pay under the working time regulations. So was Mr. Smith a worker? Yes, he was. On termination of his contract with Pimlico Plumbers, he brought various claims, including for unpaid holiday, within 3 months of the date of termination of his contract, but more than 3 months from the date of the last period of unpaid holiday. So Pimlico Plumbers argued that he was time barred from making those claims because there were more than 3 months between the last period of unpaid holiday and the bringing of the claim, which is the time limit for those. If you've got a more than 3 month gap between one holiday and another, you can't claim for a continuous deduction. That's the time limit for making those. The 3 months breaks the chain. So Mr. Smith tried to argue that he should be permitted to carry over the 4 weeks from every year and accumulate that pay until the end of the employment relationship. And he used a previous case to argue this. This case is called King and Sash Windows, which you may have come across before. Now, in that case, Mr. King, the individual concerned, had not taken any holiday because his employer had refused to pay for it. In this case, we've got Mr. Smith taking his holiday, but not getting paid. In King and Sash Windows, Mr. King didn't take any holiday. And the court said that he was effectively deterred from taking any annual leave because the employer refused to pay for it. Therefore, he must be permitted to carry over and accumulate that leave until the end of the employment relationship. So there was then this argument before the Court of Appeal on whether this could apply in Mr. Smith's case. And the Court of Appeal said that yes, it could. So where you've got an argument or a dispute about the worker's right to take paid leave, which is usually only going to arise if there's a debate about whether or not this person is genuinely self-employed or a worker, the Court of Appeal found that they only lose the right to take leave at the end of the leave year if the employer has fully informed them of their right to take it and that they're going to lose it at the end if they don't. So I think this is something that, well, you will have seen before in your own employment contracts and holiday policies in the handbook. It's something that we always draft, is that you can't carry over leave from one year to the next, or you can in certain circumstances, but if you don't use it, then you will lose it. So the Court of Appeal found that that's what employers should be doing, encouraging and informing their employees to take the holiday. If not, they're going to lose it. So as a result, Mr. Smith was allowed to take his 4 weeks leave under the European directive in respect of each leave year, and that carried forward into subsequent leave years and then accumulated at the end of the employment relationship, and he was entitled to be paid for all of that. So I think the important thing to remember with this is if you've got self-employed contractors who may be able to show that they're workers on termination, just be careful. And as you would with any worker or employee, make sure that you tell them that they can take their holiday. They should be encouraged to take it. Otherwise, they're going to lose it. So be explicit about that. Okay, so now we've got the case of Mrs. Hutchinson and Asda. And this is a case of age discrimination and disability discrimination. Mrs. Hutchinson successfully sued Asda for constructive unfair dismissal, direct age discrimination and discrimination arising from disability. And this case is really a cautionary tale to any employers who might approach a similar situation in a similar way. So let's go and have a look at what they did. Mrs. Hutchinson, age 73, had worked for Asda for 20 years. Now she started to show the early signs of dementia, and this was noticed at work. She became forgetful of her things. She was confused. She was slower in her role and she needed more help. She'd been referred to occupational health by Asda, and management had offered to speak to her family about that as well, but she had refused. she didn't want any fuss about it. Asda had also made some attempts to help her in other ways, like, for example, they changed her working hours so that she didn't have to drive home in the dark. Now, what the tribunal said about this is that even though the claimant didn't want a referral to occupational health and she was reluctant to accept the assistance that was offered, that really Asda should have done a lot more about that. First of all, they thought that Asda ought reasonably to have known about her disability because of the obvious signs of dementia that she was starting to show. She's forgetful and losing things. And they should have really investigated that a lot more. They had referred her to occupational health. They'd also given her a risk assessment, but the risk assessment was largely based on her own self-reporting. So the tribunal found that really this was more of a box-ticking exercise than a genuine sort of delve into the problems that was going on via a risk assessment. And even though Asda was never told that she was suffering from dementia, the tribunal said there was an obligation. They really should have made more inquiries about that. So it's really important for an employer to be alive to the employee's symptoms and really take all reasonable steps that you can to get an occupational health report and investigate properly if you need to. And don't undertake risk assessments merely to just box tick, actually really delve into what's going on and do those risk assessments thoroughly. Another point in this case was the age discrimination point. And the tribunal found that Asda had discriminated against Mrs. Hutchinson due to her age because her manager kept asking her when she was going to retire. Now, this really upset Mrs. Hutchinson, and it made her fearful of working there because she felt that she was too old to work there. And Asda, in their defence, said that it was well-meaning, but the tribunal really didn't like that at all. They felt the repetition point was really important to them. This manager had mentioned it on several occasions, and they said that really any retirement conversation should be instigated by the employee, not the employer. And I think that if you're ever in a situation where you believe your employee isn't capable of carrying out their role anymore, then you've really got to investigate that properly, use capability procedures, and act fairly and reasonably in all the circumstances so that you've got a fair outcome. Okay, so now we're going to go on to talk about the case of Stojsalovic and DPD. I don't know if I've pronounced that properly. If anybody knows how to pronounce that and they want to drop a comment in the comments box and tell me how I should be saying it, that would be great. So in recent years, as Matt mentioned earlier, we've seen a number of cases about worker status, from plumbers to taxi drivers, and almost unanimously courts and tribunals are coming out in favour of worker status, Uber being the most famous case of this kind, which I think I spoke about in the last webinar as well. This case is a bit of a departure from that, so it's quite interesting. So we've got these owner drivers here who had franchise agreements with DPD to collect and deliver parcels. We all know what DPD does, or we should do, shouldn't we, since lockdown. Now, the agreements had the following terms. The DPD owner driver had to supply a driver, that could be themselves or somebody else. The driver had to be over 21, have a valid driving licence and appropriate training, and they had to be authorised by DPD. So the owner drivers contended that they were contracted to DPD as individual drivers, therefore they were employees, or at the very least they were workers, therefore they should be provided with certain employment protections. DPD disagreed and argued that the owner drivers were independent contractors, therefore they were self-employed. Now, the main issue in this case is the issue of personal service. If the DPD drivers were required to perform the services personally and they couldn't send a substitute, or they could only send a substitute in very limited circumstances, then that would point to worker status. So, did the individual have to perform the work personally? What did the tribunal say? The tribunal said that the owner drivers had an unfettered right to to send a substitute in their place if they were unable to do the work themselves. The owner-drivers argued that the substitute had to satisfy certain conditions, which I've listed here. So their ability to send a substitute was fettered or compromised, so they couldn't just send anyone. The Employment Appeal Tribunal found that the franchise agreement between the parties did reflect the true arrangement between the parties, and that was that DPD was entitled to require drivers to satisfy this certain criteria. They found that DPD had no other rights to refuse that substitute if they satisfied the requirements. And the EAT held that a right to substitute is only limited by the need to show that the substitute is qualified. That's inconsistent with personal service. So that meant that the owner drivers didn't have to carry out the work personally. So as a result, they did have a genuine right of substitution, and therefore the workers weren't workers or employees, they were genuinely self-employed. But I think that's quite important to see that we got a different view on work status in that one. And then I also just wanted to briefly try and touch on these other two cases. So we've got Waters and Moat Cricket Club, which again came out that it wasn't worker status. So in this case, the cricket club employed a groundsman, which wasn't Mr. Waters. This was a totally separate person. And it was common ground that the groundsman was an employee. Now, Mr. Waters was a committee member, and sometimes he worked as a volunteer or a casual worker, and he sometimes assisted the groundsman. In 2011, he then started his own gardening and ground services business called Green Hands Gardens. And he was engaged as a self-employed contractor by the cricket club. Shortly after this, the original groundsman left, and it was agreed that Mr. Waters would replace him as a self-employed contractor. Now, the parties eventually fell out over money, and Mr. Waters tried to bring various claims based on the fact that he was actually a worker and not self-employed. So the question was whether the club was a customer of Mr. Waters, and the tribunal concluded that yes, it was. Even though the club was substantially the major customer for that business, for Green Hands Gardens, and there was a substantial financial contribution towards Mr. Waters' business, they found that it wasn't a sham arrangement and that he was genuinely self-employed. And the Employment Appeal Tribunal agreed with that. And the important point to note is that the Appeal Tribunal said that in order for the worker status test to work, it requires not only that the person does personal service, but also that they don't do so under a contract to which the other party is a client or a business. And that was key in this case, that the cricket club was a client of Green Hands Gardens. And then briefly to discuss Johnson and Transopco Limited. So Mr. Johnson was a cab driver, and he used the Transopco My Taxi app to get passengers and fares, whilst he was still employed getting his own passengers and fares as well. He could reject bookings offered through the app without a penalty and apply his own trade instead. He could reject bookings that had already been made without a penalty as well. He brought claims after the relationship had ended, claiming to be a worker, and at a preliminary hearing, all those claims were dismissed. The Appeal Tribunal also rejected his grounds of appeal and said that the claimant and the respondent, so Johnson and Transopco, were contracting with each other as two separate businesses, and there was no dependency of relationship from Mr. Johnson to Transopco. In fact, they showed that Mr. Johnson actually only accepted 1.5 trips a day on average from the My Taxi app, and that he was only achieving 15%, or only 15% of his income came from the fares on the My Taxi app. But this is something else that is important to note, that the tribunal will look at is how much financial dependency comes from the relationship. But again, it's a useful reminder. The tribunal always looks at the reality of the relationship as well as what's on paper, but each case will ultimately turn on its own facts. Okay, so I'm going to finish off today with a case about vicarious liability. This is the case of Chell and Tarmac Cement and Lime Limited. I have talked about vicarious liability before in webinars. You might remember I talked about a couple of cases a few webinars ago. But the question in this case was, can an employer be held vicariously liable for the acts of its employees when they're engaging in horseplay? Mr. Chell was employed by Rolltech Engineering, and he worked on a site that was operated by Tarmac. There were tensions between Rolltech and Tarmac fitters, and a fitter employed by Tarmac, when they were all messing about one day, used a hammer to strike a target which was near the claimant's ear, and this resulted in various personal injury to the claimant, Mr. Chell, including hearing loss and tinnitus. So he brought claims that Tarmac was vicariously liable for the actions of its fitters and was therefore liable for negligence and breach of duty to prevent foreseeable risk of injury. Now, the Court of Appeal disagreed and dismissed these claims. They did accept that horseplay, ill discipline and malice could be a mechanism for causing reasonably foreseeable risk of injury, but that wasn't made out on the facts of this case. That's what they said. Now, the question for the court is always, is the wrongful act sufficiently related to the conduct authorised by the employer to justify vicarious liability? There was another case that I talked about before. It was a Christmas party. One employee picked up another employee when they were drunk and dropped her, and she hurt her back. In that particular case, on those facts, the employer was found not to be vicariously liable. But then we've seen another case of a managing director at an after drinks party, a Christmas party, where he'd punched another member of staff, and that person had sustained brain damage, and the court found that, yes, the employer was vicariously liable for the actions of the managing director in that case, because it was sufficiently connected to his role in the company that he was in that situation. So we thought the decision in this case was a little bit harsh, actually, because really, otherwise, you can have employees messing about, as in this case, doing something quite dangerous, resulted in serious personal injury for Mr. Chell, and they've not been held liable. So I think the takeaway from this is that because generally it is that an employer would be liable if it's sufficient, if the actions are sufficiently connected to their role, you must make sure that you have robust policies in place and training on areas that might be risky. So, for example, discrimination and harassment, so that staff and managers do know what's expected of them and what constitutes unlawful behaviour. Particularly now as well, we're working from home, make sure that people who are at home still remember what the policies are and what they should and shouldn't be doing in that case. But yes, if sufficient, the connection between the wrongdoing and the employee's job, then usually the employer would be held liable. To make sure all your policies are in place for that. So I think that then concludes my session, and I will, there we go. I will hand back to Matt.
Thanks, Lindsay. That was a really interesting session. I thought there was lots of interesting cases that came up on the back of that. I agree with you on the case, the vicarious liability case. I thought it was an odd decision, very much based on its own facts, and not one that employers should take much comfort from, I think. I was also really interested in the additional Pimlico plumbers decision on holiday pay. Like you, I think it's got implications for those businesses that misclassify self-employed people when in fact they should be classified as workers. I also think you might have some general issues for employers who properly classify individuals as employees but don't do enough to make their holiday pay arrangements transparent. So
exactly,
definitely one that's worth remembering. that was great. That brings us to the end of the session. So thank you for everyone who stayed on. I hope you found the session useful. We've had some really useful chat coming through. People are saying they found it informative. So thank you for that. As I say, at the end of this, we will be sharing the recording and the slides and the resource material as well. So you'll get that through shortly. If people have got, just trying to just look at one last question actually that came in. If Chell brought the claim against his employer instead, do you think he would have won the claim? Was the vicarious liability the only factor? That's an interesting one. I think it was the strange arrangements that were in place with regard to who carried out the particular act and the arrangements that were put in place.
Yeah, he didn't work. The fitter that struck the hammer next to the ear didn't work for his employer. It wasn't another employee. He worked for the third party.
Yeah.
So I think that might have been too big a leap in that case.
Yeah, but as I say, I think it's a great question, but I wouldn't. I still think vicarious liability, certainly on the back of some of the more recent decisions, the one that Lindsay's talked about before, I think it probably still lies in favour of the employee rather than the employer at the moment. So thank you for that, and thank you for everyone who's been in attendance. Thank you for everyone who's contributed and all the chat. We've really enjoyed presenting it. As I say, you'll get the recording, and if there's issues you want us to cover or you reflect on what we've talked about and you have any questions, just let us know. So hopefully we'll see you all at the next webinar. So thank you.
Thank you.